In the Court of Appeal, Civil Division, before the Master of the Rolls, Lord Justice Moylan and Lord Justice Arnold, Wednesday the 24th of March 2021, in the matter of HSBC Bank PLC v Stanford International Bank Ltd, case numbers A3 20201629 and A3 20201664.
Yes, Mr. Kelly.
Good morning, my lord. Before I resume my submissions on the dishonest assistance claim, I just bring you up to date on a couple of things and make a couple of points in relation to the loss claim. First of all, I hope you've all been provided with a chronology of
I think we may have lost Lord Justice Moylan. I had him pinned on my screen. Oh no, he's come back.
Thank you.
Sorry, Mr. Fenwick, please continue. We've got two documents, just to cut it short perhaps. We've got two documents, one from each side and two Hong Kong cases, which I think we've all read.
Yes, I think what you should have is you have a chronology of the insolvency event, which is an agreed document in 2 pages.
Thank you.
A note from us on 2 Hong Kong authorities, and a note from a learned friend on a few Hong Kong authorities, including some taking the opportunity to say how difficult Prince Care is, which is not before the court as an issue. The authorities...
Sorry to interrupt, but I've lost all pictures, so I'm going to leave and rejoin. I will be back as soon as I can.
We all have lost the pictures, I think. So can we just see if whether Mr. Fenwick and Ms. Robertson can put their cameras on?
My camera is on, and I can see all members of the court and Ms. Robertson.
My lord, my camera is on, but I can't see any members of the court, or indeed Mr. Fenwick.
Right. Well, I'm in a similar position, so I suggest that Lord Justice Arnold and I and you, Miss Robertson, leave and return and see if that helps.
I'll do so, thank you.
Right, well that seems to have helped me.
And me.
Excellent.
And I can still see everybody, so that's satisfactory.
Well, you're always in a state of grace, Mr. Fenwick.
I try to be, my lord. Doesn't always work. I was saying that there is the separate note from Miss Robertson, which refers to a number of authorities which are somewhere in the cloud on their way to me, and they may either be in the cloud on the way to the court or have reached the court. But I don't know whether you've received the note and or the authorities.
Yes, we've received 2 authorities, 2 notes and an agreed chronology.
My lord, might I just indicate that what Mr. Fenwick was referring to is the fact that there is a clip, a PDF clip of authorities that goes with our note. So all of the authorities referred to in that note are in the PDF clip. Because it's quite a large PDF clip, we've circulated a link to your lordship's clerks for the purpose of downloading that clip.
Right, I haven't got that, but I'm sure it doesn't matter for the moment because we're listening to Mr. Fenwick on dishonesty.
Indeed, Lord, I'm not going to comment on those authorities because I haven't seen them. What is clear is there's some helpful guidance in relation to the test for the Prince Care duty, but there's nothing of real interest in relation to the question of loss, perhaps not unsurprisingly, except that there was an element of $3.25 million in DEX, where there was a no-loss argument, which the judge decided he didn't have to aside. So that doesn't take us very much further. Lord, before I leave loss, can I just mention a couple of points which, reading the transcript, may not have been sufficiently emphasized. It is in our submission clear that at all material times, and certainly by August 2008, SIB was hopelessly insolvent. Each of the payments were fraudulent dispositions by Mr. Stanford in furtherance of his Ponzi scheme. They're not payments which the company could properly have authorized, and they left SIB with a significant diminution in its assets available to it. And that is an essential part of the Ponzi scheme, whereby you have to take the money from Peter to pay Paul. Now, we say that the insolvency, when the company was eventually put into insolvency in February 2009, made no real difference. It was just as insolvent before as it was after, no less or no more insolvent, other than the losses incurred in the meanwhile. And what perhaps was not entirely clear, in relation to the decision of the Privy Council on which Miss Robertson placed reliance, in which your Lordships asked me some questions, that was not a decision made because they were monies that the company was entitled to pay. It was monies that the recipients had a contractual liability to receive if the company was solvent, including their contractual profits, even if there were no such profits. And the reason they kept them was not because there were profits to which they were entitled, but because they were without notice and treated as equities darlings, and it would have been unfair to take them away. So to suggest that these were just in the ordinary course of business, and you somehow disregard them in computing loss, is in my submission wrong. I'll now move back, if I may, to my dishonesty submissions, and I want only to look at.
But can I just, just because you make those submissions in a matter-of-fact way, but as a matter of fact, Lord Briggs did say at paragraph 66 that the holders of the certificates of deposit had a contractual entitlement to receive capital and interest by virtue of the simple terms of the certificates of deposit, either upon redemption or by way of early redemption subject to a discount, and he held that no legal principle entitled the company to recover those monies. So what I don't really understand is how you can say, of course you can say that had the Ponzi scheme been exposed and all the facts been available, Mr. Stanford would have been acting unlawfully in authorising those payments. But what's that got to do with the question of loss?
What it has to do with the question of loss is because there were payments which were made which should not have been made because of the true state of the company. As a result, the company lost money and got back only a diminution in its liabilities. It suffered a direct loss. And the fact that they had a contractual entitlement to them is no different than any other payment which is made, which diminishes the assets of the company, the cash assets of the company, at a time when the company is insolvent.
Okay, thank you.
So the first of the remaining authorities I wanted to look at is at tab 24. I have authorities. And that's the case of JSC Bank of Moscow against Claimant. And I just want to pick up a passage on page 819 from the judgment of Mr. Justice Flo, as he then was. And paragraph 19, Mr. Swainston put a test which he submitted was derived from Lord Millet's speech in these terms. The primary facts must necessarily leave inference that Mr. Claimant is guilty of fraud, because otherwise, next hypothesize, the primary facts will be consistent with innocence. You don't get to arguability if you've established as a proper fraud plea. You don't establish as a proper fraud plea before particulars are pleaded, which are only consistent with Mr. Claimant being dishonest, cannot be consistent with him being honest. I agree this overstates what is required for a valid plea of fraud. The claimant doesn't have to plead primary facts, which are only consistent with dishonesty. Correct test is whether or not, on the basis of the primary facts pleaded, an inference of dishonesty is more likely than one of innocence or negligence. As Lord Millet puts it, there must be some fact which tilts the balance and justifies an inference of dishonesty. At the interlocutory stage, when the court is considering whether the plea of fraud is a proper one, whether to strike it out, the court is not concerned with whether the evidence at trial will or will not establish fraud, but only with whether the facts are pleaded which would justify the plea of fraud. If the plea is justified, the case must go forward to trial. The assessment of whether the evidence justifies the inference is a matter for the trial judge. My next point, if I may, to go to Ivy. Which is at tab 30 in the third volume, beginning at page 994. As your lordships know, it's a case to deal with cheating, and it analyses the authorities, and it lands up a passage I want to look at page 1019, at paragraph 74. These several considerations provide convincing grounds for holding the second leg of the test propounded Gosh doesn't correctly represent law. Directions based upon it ought no longer to be given. Test of dishonesty set out by Lord Nichols. When dishonesty is in question, the fact-finding tribunal must first ascertain subjectively the actual state of the individual's knowledge or belief as to the facts. The reasonableness or otherwise of his belief is a matter of evidence, often practice, determinative, going to whether he held the belief. It is not an additional requirement that his belief must be reasonable. The question is whether it's genuinely held. And once his actual state of mind as to knowledge or belief as to facts is established, the question whether his conduct was honest or dishonest is to be determined by the fact finder by applying the objective standards of ordinary decent people. There's no requirement that the defendant must appreciate that what he has done is by those standards dishonest. In my submission, when one has a corporation as opposed to a specific identified individual, then one can apply that test to the corporation, as I will demonstrate.
Mr. Fenwick, can I ask you this question? How does a corporation have a state of knowledge or a state of belief otherwise than through human beings?
It doesn't. But it may have that knowledge through human beings. And standing back a little bit, it has at two stages. There may be the human beings on the ground dealing with the particular account and following the rules and practices, or not following them, of the entity. Those individuals may not have a dishonest state of mind. But if the institution, through those who are responsible for it, have and are committed are capable of leading them to carry out correspondent relationships with banks with whom they should not do so honestly because of grounds of suspicion. And they're aware the systems are not performing in a way which does that. And then they are reckless as to whether that state of affairs should be altered and leave it. And then there are human beings in the scale for whom the company is responsible. And the difficulty is in identifying who those individuals are when inevitably what one gets on disclosure in such a case as this is the acts of the people at the bottom and the procedures which we can identify. And when we look at the litany of failures, which we'll do very shortly, I will be submitting that to allow such a state of affairs within HSBC in dealing with these matters is reckless in the sense of dishonesty. Now, I also say that human beings must have had that awareness, and human beings must have been reckless. But I can't identify who they are, and may not be able to. What one has to do, because we're not interested, as Lord Nichols tells us, and as Lord Hughes in Ivy confirms, we're not interested in their subjective understanding of whether what is happening is dishonest or not. We are concerned with whether objectively, knowing that and being taken constructively to have that knowledge through the company, their conduct is objectively reckless and therefore dishonest. And if I establish that in my submission, I'm entitled to relief for accessory liability, dishonest assistance. If I don't, and the court concludes when it's seen and heard all the evidence, that all of the people who come forward were in fact acting in good faith, if incompetently, then I'll try.
I want to check with you, Mr. Fenwick, that I've got your submission clear, because I think we may have reached a point where it is reasonably clear, and I want to just read to you what I've written down. It's a bit of a summary, so correct it if you want to. To allow the failures that I have pleaded is recklessly dishonest, and human beings must have had that state of awareness, but I may not be able to identify those human beings, but there is no need to do so, as we are not interested in their subjective view, Lord Nichols, only with the objective question of whether the conduct is objectively dishonest.
Yes, my Lord. I think that adequately summarizes what I've been struggling to say.
Well, it's what you said, so thank you.
Lord, may we go to the last of the authorities on the test for dishonesty, which is group 7, because it conveniently brings us up to date after a very thorough analysis of the authorities. And I want to see where we're left at the end of that summary. We can pick it up. It's tab 33 in volume 4. I was going to start at the bottom of 1192. Paragraph 58. In the light of Ivy, it must, in our view, now be treated as settled law that the touchstone of accessory liability for breach of trust or fiduciary duty is indeed dishonesty, as Lord Nichols so clearly explained in Tan, and that there is no room in the application of that test for the now discredited subjective second limb of the gauche test. That's not to say, of course, the subjective knowledge and state of mind of the defendant are unimportant. On the contrary, the defendant's actual state of knowledge and belief as to relevant facts forms a crucial part of the first stage of the test of dishonesty. One notes there, knowledge and belief as to facts. Once the relevant facts have been ascertained, including the defendant's state of knowledge or belief as to the facts, the standard of appraisal, which must then be applied to those facts, is a purely objective one. The court has to ask itself what is essentially a jury question, namely whether the defendant's conduct was honest or dishonest, according to the standards of ordinary decent people. So post-Pan and post-Ivy, missing out the wrong turn in Twin Sectra, we're not interested in the innocence in the state of mind of the individual. We're interested in his knowledge, and we're interested in his any beliefs which may be relevant. And in Leach, of course, Twin Sectra, it was Mr. Paul Leach's belief held in good faith that what he was doing was authorized, which negated the dishonest implication which otherwise would have arisen. And that's the same, both subjectively and objectively. Then, 59, the discussion of knowledge by Lord Hoppe and Lord Millet in Twin Sectra indicate knowledge of a fact may be imputed to a person if he turns a blind eye to it, as Nelson supposed to have done at Copenhagen, or deliberately abstains from inquiry to avoid certain knowledge of what he already suspects to be the case. So, an individual responsible for running the company who allowed a state of affairs to continue, which was likely to mean that danger signs were missed, and did so recklessly, can have knowledge of what might be found, if they'd looked, imputed to them. In the context of dishonest assistance breach of trust, it was common ground between us to equate blind eye knowledge with actual knowledge. That's the first stage of the test. It's important, however, to understand the limits of the doctrine. Not enough that the defendant merely suspects something to be the case, or negligently refrains from making further inquiries. The imputation of blind eye knowledge requires two conditions. The first is existence of suspicion certain facts may exist. The second is a conscious decision to refrain from taking any steps to confirm their existence. The judgment also makes clear that the existence of the suspicion is judged subjectively by reference to the beliefs of the relevant person. The decision to avoid obtaining confirmation must be deliberate. Then a quote from Lord Scott's speech. And then I want to go to paragraph 61. Where the conditions for imputation of blind eye knowledge are satisfied, the person is treated for the purpose of establishing liability for dishonest assistance as if he had actual knowledge of the relevant facts. We don't think it follows from this, however, that suspicions which fall short of constituting blind eye knowledge are wholly irrelevant to the question whether an alleged accessory has acted dishonestly. The first stage of the test, as it is now understood, requires the court to ascertain all relevant facts, including the knowledge and beliefs of the defendant, falling there in a corporate entity. That's the knowledge and belief of all relevant persons of the defendant. Even though knowledge in this context must now be taken to be confined to actual and blind eye knowledge, we see no reason in principle why a person's beliefs may not include suspicions which he harbours, but which in and of themselves fall short of constituting blind eye knowledge. The existence of such suspicions and the weight, if any, to be attributed to them are then matters to be taken into account at the objective second stage of the test. Or to make the point in a different way, the existence of a legal technique for imputing constructive knowledge, if certain conditions are satisfied, should not be taken as implicitly restricting the scope of the subjective inquiry into a person's state of mind and belief at the first stage. The state of the person's mind is in principle a pure question of fact. Suspicion of all types and degrees of probability may form part of it, and thus form part of the overall picture to which the objective standard of dishonesty is to be applied. And now, pausing that, and after a brief look at the sofa, I'm then going to go to our submissions and the pleading. There are two points which in my submission arise. The first is what has to look in a case where dishonesty is pleaded against a corporate entity at all the facts, all the actual and constructive knowledge of those who are involved in representing the company at all stages of the events against which criticism is made. It's at that stage that you then take an objective view and say, looked at objectively, is a person or entity with that knowledge to be regarded as dishonest. Now, no problem exists where there is a single person or two conspirators who are alleged to have been dishonest in this way, because the court doesn't have to look beyond the individuals. But none of these cases are cases which deal with where the wrongdoing goes beyond one or two specific individuals and imbues the conduct of the entity, so that what is complained of is the overall turning of a blind eye to the risk of misconduct in correspondent relationships by the bank in the way it arranges and manages its affairs. And it does require, in my submission, the court to be astute to enable the investigation to take place in order to conclude at the end of the day whether there is sufficient knowledge within a company, making sure we don't add one innocent to another innocent, sufficient conduct within the company that the plea of recklessness and dishonest assistance is made out. And that will be by looking at individuals, some of whom may come to give evidence and some of whom may not.
Mr. Pennick, I apologise if I'm asking the same question again, but can I ask this? How does a corporation turn a blind eye to misconduct otherwise than by human beings?
It doesn't. But the human beings who are doing that, when you have a company which acts collectively, may not be readily identifiable. But one has to look and say, here is, for example, a report submitted to a board. The report identifies very serious shortcomings in the way in which correspondent relationships are managed and scope for fraud in some of those relationships. The board looks at it, decides to do nothing about it. It goes to another board, does nothing about it. In my submission, there is sufficient human knowledge, there is sufficient misconduct for that to give rise to a successful plea of recklessness. But the difficulty I face is that in those circumstances, there is no more serious claim against a specific individual than to say, you, Mr. X, the chairman of the board, you, Mr. Y, the managing director, personally were dishonest in this respect. They may say, well, I was only listening with half an ear, and it was agreed by everybody else, I didn't notice. It may be that I've seen too many inadequate pleas of dishonesty, but it is a salutary requirement that before you plead it against an individual, you have to have specific evidence against that individual. And that specific evidence has not emerged at this stage and may not emerge. If I knew who was responsible for and had allowed the things we plead to happen, then I could plead it against them. At the moment, I can't. I may not be able to. And for the reasons identified in the summary of what I was trying to say by the Master of the Rolls, in my submission, that should not matter when one comes to the second stage. But of course I accept that a company doesn't act independently of human beings. Well, may I just touch briefly on SOFA, because that is the genesis of the first question.
I'll just ask one other rider to that. You said immediately before my lord asked you his question that, of course, you would do all that. The court, you said, must be astute to enable that investigation to take place, making sure that we don't add one innocent to another innocent. But if you are never in a position to make an allegation of lack of innocence against any individual, is it not inevitable that you will be asking the court to find dishonesty by adding the knowledge of an innocent to another innocent?
No, my lord, because adding the knowledge of an innocent to another innocent doesn't give either of those innocents guilty knowledge so that you can say that they are dishonest in that they must have known position. Where you have a collection of individuals, such as a board or a group of managers, then although each one on their own may say, well, I didn't think of that, if they collectively allow something to happen, knowing that systems are not in place, knowing that the systems are inadequate, and then the board as a whole, the management team as a whole, is turning a blind eye. And that may be more than one individual. And it may indeed be that at the end of the day, when you identify where the decision was taken, and when you identify how it was that this occurred, you conclude that one or two of those individuals was in fact dishonest. And there one has this tension between the obligation when pleading fraud to identify distinctly and clearly those who you say are dishonest, and the difficulty of being able to do so when the facts are not entirely clear until they've been investigated. It doesn't mean to say that in that case you can effectively avoid any claim for dishonest assistance against a company by making it really difficult to find out who actually was responsible. Now, Lord, so far, I'm sure the court is aware of, and I really wanted, because we put a certain amount in it in our submissions, to go directly in tab 37, volume 4, to the judgment of Lord Justice Arnold, paragraph 32, where he said this: whether or not it's technically binding, I see no reason to differ from Lord Justice Peter Gibson's statement of principle. I do not doubt where an allegation of dishonesty is made against a body corporate, it is necessary to plead the relevant state of knowledge of that body at the relevant time. I do not accept, however, that the mere failure to identify at the outset the directors, officers, or employees who had that knowledge means that such an allegation is liable to be struck out without further ado. Clearly, such particulars should be given as soon as is feasible. There may be situations in which the claimant's unwillingness or inability to give such particulars when requested to do so justifies striking out, but that's another matter. We say that we are in that position now. We hope that we won't be in that position when disclosure is over, as and when during the process of this trial, including the service of witness statements, it becomes possible for us to identify the individuals who we say were responsible through their knowledge and conduct and blind-eye conduct as dishonest, we will do so. But sometimes these matters emerge only at trial. The important thing is that there is a clear pleading of what it is alleged to have been done wrong, and a clear pleading of what is said to be dishonest, so that that can be addressed by the defendant. My Lord, I'm now going to turn to this case in the light of those authorities. And first of all, I take up my Lord Master Earl's question to me as to whether we have adequately covered the fact that we may not be able to identify the individual. And you asked whether our appeal was wide enough to cover the argument. Now, our grounds of appeal, which are commendably brief, the edict not to say why the decision is wrong or unjust in the grounds of appeal, but in the skeleton argument. We say at ground one, when we're dealing specifically with SOFA, that the learned judge should have held the appellant's pleadings as a page, I think it's still 11 of the bundle because the number it doesn't change yet. Pleading identifies the relevant state of knowledge held by HSBC at the relevant time, i.e. dishonesty, a viable basis for a plea of dishonesty, such he ought not to have struck out the dishonest assistance claim. And ground two, the claim is not bound to fail as a matter of law. In any event, the law relating to the dishonesty of and or attribution of dishonesty to corporate entities is sufficiently complicated, fact-sensitive, and capable of development. The dishonest assistance claim was not suitable for summary judgment and should not have been struck out. Now, that was dated 28th September and was accompanied by our a skeleton argument. And if you go within the skeleton argument to first of all, paragraph 53, page 32. We say we accept knowledge from two or more innocent persons cannot be aggregated to create a dishonest state of mind. Nothing more takes case beyond the four walls of the authority. One, where the knowledge of a natural person is involved, the application of the test is straightforward. Policy considerations which make blind eye knowledge sufficient are obvious, lack of inquiries. Three, although corporate entity can only have such knowledge and suspicions are held by its officers and employees whose knowledge falls to be attributed to the company, by Lord Justice Arnold's point, it can only take appropriate action in respect to the matters known to individuals, officers, and employees if that knowledge is reported to or concentrated in an individual with the relevant authority to do something. For these reasons, in addition to the key importance of preventing and detecting financial fraud, large institutions such as banks are required to have in place policies and procedures to enable information to be considered and monitored by the appropriate individual. Facts which must be assumed include the application of policies and procedures was, as a result of systemic failures, reckless as a matter of fact, as reckless neither knowing nor caring whether it would detect fraud, with the result that knowledge, which would otherwise concentrate one individual, was not so concentrated and was instead fragmented. The reason for the reckless application of their policies was because it was not in their interest to take steps that might have interfered with or reduced or stopped a highly lucrative stream. So we say the ingrained culture of recklessness, reckless application of policies and procedures designed to prevent such fragmentation. There's no reason why that should not make company responsible. And we go on at 55. Reckless in its failure to institute and or operate appropriate systems, procedures, and or policies. The result of knowledge which should have been collated, which could not properly have been disregarded, was instead dispersed. So the failure is not at the level of the person at the bottom who didn't have the knowledge, but at the person at the top who allowed that knowledge to be dispersed in a reckless manner. Not enough to prove carelessness. And then 3, HSBC is to be regarded as having corporate knowledge of relevant matters, because it applies in a reckless manner the policies it ought to have operated. It properly applied would allow it to identify the wrongdoing. That wasn't a machine doing it, I made clear. That was individuals who allowed that to happen. Human beings. It was that recklessness by HSBC taking the form of an ingrained culture and systemic failures rather than one-off or isolated occurrence, which prevented one individual from having the relevant knowledge when the very purpose of the policy, that's the relevant knowledge at the SIB level.
Puzzled by the way you put it in paragraph 55. You say there's a reckless failure to institute policies. Now, I do not understand if you say there was an obligation on HSBC to institute policies, why you cannot readily identify the individuals who were charged with that responsibility.
Following disclosure and further disclosure as required, we should be able to do so, I agree. But we can't do it.
Well, it starts with the board, doesn't it? You know the names of the board of directors, you know their functions. If you are alleging the board failed to institute policies, you can say these were the members of the board at the relevant time, these were their functions as members of the board, they failed to institute policies and they were reckless.
If I was dealing with a medium-sized English company, I could do that. I'm dealing with a worldwide organisation with multiple boards. And I'm still not, after 40 years, prepared to make an allegation of dishonesty against an individual until I have clear enough information as to that person's involvement. If I don't have a board meeting at which I can see they discussed it and thought about it, I can't make that allegation against an individual. There are plenty of barristers who would, but in my submission, it is not correct to do so.
But your case is not that they discussed it. Your case is that they ought to have done it and they didn't.
Well, yes, in one sense, but that in itself could be mere negligence. It is the amalgamation of the multiple failures taken at every level by individuals within HSBC. It's people who failed to manage and monitor KYC, seemingly neither knowing nor caring whether that KYC monitoring was brought up to date. It's people who failed to disseminate knowledge in one part to another. All of that, if done merely negligently, I will fail. If one can show that the way in which it was done was reckless, we've been at some pains to plead in some detail what we say was the conduct and failures. And then in my submission is the claim that we're entitled to make. We didn't make it lightly. I didn't just bung in recklessly so that I can have a claim where I know, because I know that if it was negligent, I wouldn't get home. This has been a very carefully, lengthily thought out decision that looked at as a whole. The conduct of this organisation was reckless. It was reckless because human beings were aware of what was going wrong and didn't do anything about it. And that's not just one board on one decision. It is not a thing. This is a remarkable case. In most cases, you have 4 or 5 acts of negligence. You may have a completely hopeless company. This is HSBC, a magnificent international organization, but it is responsible for very significant failures in this respect, which we've identified in our pleading. And
well, I think it's time to look at that pleading.
yes, I was just turning to it, my lord.
Yes.
So we summarise this part of it at page 157. I'm not sure whether we've jumped 2 pages yet. I've got it at 157, paragraph 5. Maybe at 159.
So 157 of what?
Of the core bundle.
And you're looking at the pleading now?
I'm looking at the pleading, particulars of claim, paragraph 5.
Okay, thank you.
The summary is that HSBC recklessly allowed systems to develop, a culture to become ingrained in its employees, which failed to pay any proper heed to the requirements of due diligence in the operation of corresponding banking relationships, including particularly with SIB. This allowed warning signs and red flags to be missed and or ignored and permitted SIB to be operated as a dishonest Ponzi scheme under the umbrella of its correspondent banking relationship, while HSB was content to make substantial profits from the use of SIB funds left on deposit in non-interest-bearing accounts. Remarkably, something like $4 million a year. Now, I ask this question. If we can show all these failures and that their absence, or the presence of such failures, was so inexplicable as to be reckless, then objectively we would say that the conduct should be treated as being reckless. We then go on, if we go to page 159, and this is paragraph 6, subparagraphs 9 and 11. By the 1st of August 2008 at the latest, HSB as an entity had or should have had information and or knowledge that would have caused any individual banker in whom such knowledge was collected, with acting reasonably and honestly, to have serious concerns about criminal conduct and or money laundering in relation to SIB and or the accounts, and or credible grounds of suspecting money laundering and criminal conduct, activity and breach of duties owed to SIB by its officers or employees were taking place. And then the plea at 11, and then they dishonestly and or recklessly assisted, as explained, in the perpetration of the fraud by providing and continuing to operate the accounts, which were a key mechanism. And then we make it 12, liable to account as a trustee, and 13, we make bluntly the point that we can't identify an individual at this stage. If we go forward, please, to page so a large amount of history, and then if we go to page 202, we set out at 151 the procedures which HSBC said it had. They've gone on flat. a number of paragraphs. And then at 210, paragraph 157, we set out what they would or should have taken had we had available the information material set out below. So, evidence of the accounts. 4 complete years of activity, completely inconsistent with the explanations of SIB's business, and the completely inconsistent with a genuine investment business. And that's pleaded for a number of pages until 215. And we must be taken to prove those matters. Then 160, the annual report, which, as we see at 216, shows some remarkable features. 11.2% return in 2007. Paragraph 6, alleging that 164 million came from interest on cash deposits of $627 million and loans of 69. That would mean an interest rate of 23.6%. Yet HSBC knew there was £80 million sitting in a current account earning no interest. Then we point at 218. And business Latin America, matching closely HSBC's own description of large business offer fraud, as described in its compliance manual. Limited information in the accounts. Introduction by the overseas affiliate in Panama. And that's where it all started. The general relationship manager was in Panama right until nearly the end. Close end relationship with Antigua. Politically exposed persons according to Blackman. Instructions given by the wrong people. Over the page, references asked for. Request for a Swiss franc account. Inadequate information given at 12. Then 162, HSBC failed to comply with its own statutory obligations and internal procedures, and a whole number of those. KYCs effective at every stage. No review at appropriate moments. 164, reasonable honest banker aware of the facts that would have been concerned about failures, wondered why a bank taking in money for investment would simply allow it to sit on deposit. And then we say at 165, so far as necessary for SIB to identify each individual had access to that information, the obligation to review it was Mr. Weir and Mr. Whitehouse. We say some things about Mr. Weir and Mr. Whitehouse. If something had been done, no prospect, if 168, SIB could have satisfied any reasonable inquiries, what they would have found, RAS, former bankrupt, and so on, all the judgment, endless red flags, and they're set out all the way through as the things which would have found. So the slightest inquiry should have led to all of these matters. Now, those we rely on, of course, in relation also to Quinscare, but if we come to page 231, is where we make our plea of dishonest and reckless assistance. We identify at 232 the elements which the judge found to be found, breach of trust by Stanford, assistance, and then we come to dishonesty and recklessness. Facts and matters which various individuals had knowledge, or would have had knowledge, but for reckless failure to take steps and to follow their procedures, are set out above, and I've shown them to you.
Sorry, Mr. Fennick, which paragraph are you on, or which case?
175, my lord.
Sorry, 175.
175.
Yeah, sorry, I was behind. Yes, thank you.
Facts of matters of which they had knowledge or would have had knowledge, reckless failure to take appropriate steps, and follow policies set out, and I've taken you through those fairly quickly because of time. Had it not been for such reckless failures, that knowledge which is attributable to HSB as employer would have been held by at least one natural person to a sufficient extent such person could not, without dishonesty or turning a blind eye, have regarded it. They were such, if they'd been known to or disregarded or ignored by a single person, would have meant that person would have been dishonestly assisting. 177. Any individual allowing the opening and operation of the accounts in those circumstances would be regarded as exhibiting Nelsonian blindness or acting recklessly. So that's what happened. If that knowledge had been properly aggregated, because of not the happenstance, not because of negligence, but because there had not been this corporate failure, this ingrained culture where all these obligations were ignored, then there would have been individuals who could have been identified specifically at this stage as being responsible. We say at 178, HSB as an entity is to be regarded as having had knowledge of these facts and matters amounting to dishonesty, not because of the knowledge of one single individual, on the assumption we can't find one, because it acted with corporate recklessness by reference to the aggregated knowledge held, either knew nor care and turned a blind eye as to whether it was being run dishonestly. These are the circumstances. Should have instituted, applied proper policies, systems and procedures, ensured when the knowledge was received by and or available to individuals, properly reported, recorded, collated and or reviewed. Instead, allowed or turned a blind eye to the development of an ingrained culture of failing to obtain and or segregating and fragmenting knowledge. So there was no system by which everything was collated in a way. It wasn't just a failure to do it properly. There wasn't a proper system. Procedures and training as applied in practice ensured personal and or individual ignorance and or compartmentalized knowledge, causing and or leading to and or resulting in what we call institutional Nelsonian blindness, despite the money laundering regulation, despite the Proceeds of Crimes Act. And as a corporate entity, applied its policies and or procedures and conducted itself in a manner contrary to the standards deemed to be commercially acceptable by reasonable and honest people. And then we set out the things which they failed to do: reasonable and appropriate policies, educating the staff, appointing staff with relevant knowledge, skepticism, procedures, and so on. Then we give some examples of this in paragraph 180. And here we identify individuals. So, Ms. Gonzalez Real opened the account without any bank mandate. Those and Mr. Aylward put their name to the KYC profile without carrying out any checks. None of them followed up. There's 3. Mr. Brooks signed the OLAM customer agreement 11 months before it was completed by the client. Accepted something which should not have been accepted. 6, Mr. Brooks, Mr. Ware put their names to the profile confirming falsely and or recklessly transactions consistent with the customer's known legitimate business activity. So these are individuals who've acted falsely and recklessly. Mr. Barnford, Mr. Annable didn't follow up on the request. Mr. Barnford continued to act as a relationship manager despite having no idea who SIB were. And so it goes on for pages by specific examples, specific conduct. Go on, if you would, to 238, paragraph 14. The review by the compliance team of the KYC documentation was woefully inadequate. Mr. K was reviewing a high-risk profile of an onshore offshore bank, cause for concern for front office bankers, let alone a compliance officer. yet he didn't pick up any of the deficiencies in the form. He simply looked at the supporting documentation, of which there was very little. That would have been a red flag, was simply left at that. And 17 on page 239, despite taking over as GRM, May 2008, Mr. Whitehouse failed to carry out any proper review of HSBC's relationship, the activity, material which they held. So all of these are failings, they're culpable failings. Do I say that any of these individuals knew, in a gosh sense, that what they were doing was dishonest? No, and I don't have to. But they had the knowledge, they hadn't done these things, each of them. And the effect of all this, as we say at 181, is that HSBC allowed large pools of hundreds of clients, including those categorized as medium and high risk, including offshore banks, to be managed reactively and anonymously by apparently inexperienced and uninformed employees with no or no adequate oversight, supervision and or review. In my submission, that's reckless. And you have to assume for these purposes that I will prove it. HSB's operations in practice, and there was no credit risk to HSBC encouraged individual failure to take responsibility and or ignorance of relevant information, and a widespread failure to collate and act on relevant information, including knowledge policies and procedures were not being followed. That's reckless in an objective sense. 3, their corporate structure, operation, day-to-day management policies, procedures allowed the relationship to continue to develop, the accounts to operate, reckless as to whether or not fiduciary and or trust duties were being breached, money laundering being committed, offences being made, and SIV trading while insolvent. That's recklessly dishonest, as we say. Operating a dysfunctional structure led to a sequence of events. None of the individuals took responsibility for applying the appropriate procedures. We say that was reckless, not merely negligent. In all circumstances, brings it together, recklessly operated and caused or permitted to develop a culture and method of operating its business, which permitted and caused knowledge to be dissipated between individuals when it should have been accumulated and acted upon by one or more of its executives, and in so doing acted in a manner which amounted to corporate recklessness sufficient to give rise to liability for dishonest assistance. Now, just pausing there. Firstly, we have identified those individuals whom we are aware who contributed by their misconduct to this recklessness. We have identified the failures which we say were reckless because we say that no honest banker could have allowed such habits, procedures and failures to develop. If one stands back, as per Lord Nichols, as per Ivy, having found all facts and all those which are found at trial, and says, would an honest bank have done that? And if the answer is no, that in my submission is sufficient to ground dishonesty for corporate liability. It is not necessary to say A was dishonest in this respect if the overall knowledge is such that you can infer that those responsible for the management of HSBC must have known of these failures and must have decided recklessly to allow them to continue.
Can I ask, Mr. Fenwick, I mean, I'm hearing this argument, so if I may say so, so persuasively developed. I'm just amazed, really, that there hasn't been a case where this precise point has been discussed, even in the Commonwealth. And at the risk of getting your juniors running around again, it does strike me that there must be, I mean, all the cases we've looked at don't really deal with the dishonesty of large corporations. Now, I mean, you know, I've involved in cases of this kind all my professional life, as you have, and I can't immediately call to mind this precise point arising, but I just find it hard to believe it never has.
Well, I understand that. I can tell you that over a lengthy period of years with a number of juniors much cleverer than I, we've looked around the world to see if we can find things which decided it either way, because one doesn't bring such a claim without very careful thought and scrutiny. We will do another trawl, and we'll look back through on this to see if we can find anything which would assist the court. But there is perhaps a reason for it. The law, tried to say the law developed incrementally, but we have seen in the last 10 or 20 years, not just the sort of the later stages of the development of the law of tort and the law of negligence, and an identification of exactly where we are in dishonest assistance, which flitted between Mr. Justice Andrew Thomas in Selangor and Lord Hutton in Twin Sector at the two ends of the spectrum in modern terms. But we've also come across two other factors which are relevant. The first is the concept that a company can be to blame, which has come in the statutory sphere, corporate responsibility, strict liability for spillage of waste, criminal offences of a company which infer liability on a corporation. So one doesn't have the corporation as this distinct thing, separate from its officers. And secondly, business has got a great deal more complicated. When I first banked a cheque from my first earnings, which was not as long ago as it might have been, when I first banked my army pay, I suppose, one went along to the bank manager and he probably knew him. And he probably said, "Your overdraft's getting a bit high, Mr. Fenn." Or, "Thank goodness you're not in overdraft anymore," or whatever it was. We now have very large corporations with massively complicated electronic systems and delegation. So you have here a case where an entity of Antigua, much of its activities were managed by a group in Texas, established a relationship with a massive world-sized bank, much larger than the entity I knew in Hong Kong 40 years ago, in Panama, where SIB had virtually no business. And the business of SIB was managed from Panama and a bit in London, through a whole host of different people. And we're now getting to a stage where the kind of tests which were being applied by Lord Hughes in Ivy and by Lord Nichols in Tan may need to be looked at in the context of international companies. One thinks in these instances of some of the interest rate fixing arguments. There are still endless mis-selling issues. They're mostly dealt with in a different way. But in the context of accessory liability, we've probably got to a time when this does need to be looked at. And in my submission, in this kind of area of the law, this is something which is best decided, as Lord Hughes said, in the context of the actual facts, rather than as an arid strikeout. But we will find something, and we will let your lordships know. Would you give us until perhaps the end of tomorrow, or would that be too late?
Instead of giving it till the end of tomorrow, Mr. Fenwick, indeed, you might even be a little more generous than that if you thought there was a possibility of finding something useful. But let's proceed with your submissions. Have you got to the end of the pleading?
I've got to the end of the pleadings, and I think I've finished, but we have our short break, and I'll just check my notes and confirm if there's anything more I need to say. I think I've had my time as well.
Thank you. We'll take a short break and resume at 11:50. Thank you.
You're muted.
I need to pay the fine for being muted. Forgive me. I can see my colleagues, and just wanted to ask Mr. Fenwick if you thought of anything else that you needed to say before you finish your submissions.
Almost nothing. Perhaps 2 minutes, perhaps less. I just wanted to draw attention to the fact that it is clear that something very serious had gone wrong within HSBC, which we say is sufficient to be recklessness, and the passages at pages 200 to 201 of the bundle, paragraphs 140 to 146, which shows the recognition after the event that something had gone seriously wrong, and there have been numerous failures, numerous rumours, and nobody knew this client, no relationships, is a good indication of that. The second thing I want to say is this. Of course, if your lordships were to decide that neither the loss point nor the dishonesty point had any merit such that it was strikeable, applying the correct test, leaving me with only the Privy Board, that will be your decision. But I do urge on this court that if either of these is accepted as a viable claim on the test, they both engage exactly the same facts, exactly the same inquiries, and exactly the same inquiries as to loss. And of course, it's accepted that on the dishonest assistance claim, that the no loss argument doesn't arise. So I would invite the court to allow both to go to trial. That's what I wanted to say at this stage.
Thank you. Do either of my lords have any questions for Mr. Fenwick?
Not from me, thank you.
Good. Ms. Robinson.
Thank you, my lord. By way of completing the report on the homework, my lord, can I just confirm that there is a nil return on Nemgia? Both Miss Hutton and Mr. Langley have searched, and we can find no sign of what became of the company court action. As your lordship's seen, we have put in a note on Commonwealth cases, and we're extremely grateful for the prompt to look at that, because I have to say it hadn't occurred to us to do so. Your lordship will see that there are some cases elsewhere where Queen's Care claims have succeeded. So although it's correct that Singularis is the only one so far in this jurisdiction, there has been some success elsewhere. There is one case where the issue of discharge of a debt arose. That's DEX, as my learned friend Mr. Fenwick mentioned. It's dealt with in our note. Your lordship should receive the PDF including that. But the short point is that the case was decided on other grounds to do with absence of authority. Now, that, of course, doesn't arise on our facts. My lord, just briefly replying on loss, I just wanted to sweep up a couple of points on loss, and I won't take up much time on them. I just wanted to make clear, my lord, that we do accept that it's arguable, for the purposes of this application, that there's a breach of a Queen's Care duty. We will have a lot to say about the merit of the Queen's Care claim on the facts of this case if this matter were to proceed to trial. But I emphasise we're not seeking to say that on this application. Our objective with this application was, as it were, the surgical strike in the form of what we say is a knockout point on loss, and not what you might call the death by 1,000 cuts that I shall aim to inflict if this matter staggers on to trial. So we need to stay focused on loss. Scope of duty, my lords, does come into it in contrasting the nature of the Queen's Care duty and that of directors. But for present purposes, as I say, take it to be arguable that HSBC is in breach of duty by failing to spot warning signs of a Ponzi scheme. And my learned friend Mr. Fenwick might say that it follows from that there must be at least a question mark over insolvency, because that's rather in the nature of schemes. That is, therefore, what it said, arguably the reasonable banker should have known. The point I wanted to make is simply this, that this case differs from the facts of Daiwa, Singularis and Daiwa, because there the bank actually did know there was a question mark about solvency. Now, not even on those facts, which differ from ours because it's not alleged HSBC did know as opposed to should have, even on those facts, it didn't affect the scope of duty, and it didn't suddenly make the distribution of assets to creditors something that was within scope. Lord, the second point I just wanted to make sure there was no misunderstanding about is our position in relation to the 80 million and whether that might have been paid from other accounts. What we say in relation to that, my lord, is the court cannot assume for the purposes of this application that the 80 million would not have been paid from other accounts of SIBS, because SIB has not pleaded that. SIB's in a position to know what the overall financial position was, and it has not pleaded that. The only thing that SIB has pleaded is that if HSBC had frozen the accounts, that money would not have gone out from HSBC. We say if SIB was running a different case in that respect, it would need to have pleaded that. One can well understand why they haven't, because I've already made the point that they had other major banking relationships. Now, just to conclude on loss, my lords, early on in my submissions on loss, I confess, somewhat flummoxed by a question from my Lord Justice Arnold as to whether our submission is that the answer is as old as Salomon, because that question made me realise that it hadn't occurred to us in a million years to cite in our skeleton argument. Lords, one doesn't think in 2020 that one needs authority for the proposition that a company has separate legal personality. But my Lord, Mr. Justice Arnold Lord Justice Arnold is right, of course, that is ultimately the root of our answer to the loss problem. You must focus on the benefit to the company, a separate legal personality, and we say that that benefit is the full amount of the debt discharged, because even if it be the case that the company is de facto insolvent at the point in time the payments are made, the creditors who are paid are, at that point in time, entitled to their full contractual entitlement. And it's only when the company enters liquidation that the entitlement changes to a pari passu share. And your lordships now have the chronology in that respect. That occurs well after the period of the claim. That supervening event of insolvency, we say, does not affect the correct measure as at the date of breach. And I just wanted to make clear, my lords, that we say is the answer, irrespective of whether the company is operating in a regime like that in this jurisdiction, which allows clawbacks in appropriate cases once liquidation has begun, or in a jurisdiction like Antigua, where that's not possible. It's not our case that the analysis on loss is transformed because of the quirk of Antiguan law that prevents SIB clawing back. And I just wanted to clarify that because I can understand that it might seem unattractive to seek to exploit that quirk. My lords, as to the justice of the situation, as Lord Sumption recognised in Fairfield's Sentry, and your lordships have this cited in the very first paragraph of the Privy Council's decision in re Stanford, it's inherent in a Ponzi scheme that those who get out in time escape without loss, and the loss falls on those who are unfortunate enough not to do so. But as I have kept emphasising, perhaps ad nauseam, the bank owed no duty to SIB's creditors. The duty was owed to SIB and SIB alone, and it's only whether SIB has suffered a loss that's relevant. So, my lords, unless there was anything else on the loss point, that was everything I was going to say by way of reply, and then move on to our submissions on dishonest assistance.
Only this, Ms. Robertson, if you were prima facie right about loss, but prima facie wrong about dishonest assistance, what do you say about Mr. Fenwick's submission that we should anyway let the loss go through to trial because there's going to be a massive investigation of HSBC's alleged misconduct, and it would be perhaps unfair to SIB to foreclose arguments about loss which might appear on the facts?
Well, my lord, in relation to the loss point as it stands in relation to Quinn's care, it can't alter according to the facts. The facts are undisputed. They're not going to change through disclosure. SIB knows the position in terms of what went out of its accounts, and it said so in Miss Jenkins's evidence. So the facts, as far as that's concerned, are fixed, as it were, and therefore it's a classic example of, if it's bad in law, grasp the nettle now and focus the litigation on what remains of anything that's viable. Now, it won't have escaped your lordships that Mr. Fenwick didn't develop his argument on the company cases he relies on to rebut the loss point. And that's because he is now focusing his firepower on the territory of dishonest assistance, because that's the last desperate play to be able to retain the argument at trial that this case is worth 80 million or 118.5 million or whatever he says the correct figure is, rather than the 2.4 million sterling that's involved in the ECB payment. So we've seen, I think, that strategy, of course, skillfully deployed as ever it may be. But now I shall launch into saying why your lordships should feel entirely comfortable that there is not a viable dishonest assistance claim on the face of the pleadings as matters stand, and that therefore that the judge was right to conclude that that claim was bad in law and should be struck out. So 4 points by way of preamble, my lords. First, the basis on which SIB sought to attribute knowledge to HSBC as an entity so as to render it dishonest is legally unsustainable, and that's a straightforward application of the long-established principle that you can't add innocent mind to innocent mind to produce a guilty mind. Second, the submission developed in oral submissions yesterday and today that dishonesty can be found against a corporation without regard to the subjective state and knowledge of a human mind is flatly contrary to authority. And indeed, at times that was the submission that Mr. Fenwick appeared to be advancing, and at other times the submission was, well, yes, he has to find a mind, but he just hasn't found it yet. Whether the basis for alleging dishonesty is put in terms of guilty knowledge, turning a blind eye to suspicions, or just not caring one way or the other about a known risk to another's rights, there has to be, as my Lord Justice Arnold has pointed out, a human mind in that state whose dishonesty can be attributed to the corporation. Third, in that respect, there is a crucial missing element in SIB's case, in that it's nowhere alleged that HSBC as an entity, or anyone at HSBC, suspected SIB's business was fraudulent and turned a blind eye to that suspicion. Nor, turning to how Mr. Fenwick sought to develop the argument yesterday, is it alleged that any of the individuals who managed SIB's accounts didn't care one way or the other whether SIB was being run as a fraudulent scheme. And nor, my lords, is it alleged that HSBC as an entity didn't care whether its systems and processes were adequate to intercept fraud. I'll take your lordships back to the pleadings, because we will find in the reply that SIB expressly disavows any such case, and yet that appears to be the case Mr. Fenwick was seeking to develop. Fourth, in those circumstances, the pleaded dishonesty case, we say, is nothing more than a negligence claim in fancy dress, decorated with spangles in the form of occasional sprinklings of the word recklessness, but with nothing, my lords, to tip the balance so as to make dishonesty the more likely inference to be drawn from the particulars that are relied upon. The particulars, of course, being the particulars that are also relied upon for the Quince-Care claim, a claim in negligence. We say the pleading would be inadequate as against an individual and is equally inadequate as against a corporate body. Now, on the basis the pleading didn't disclose a viable claim, the judge was right to distinguish SOFA, because as I'll come to towards the end of my submission, SOFA is a case where there was a sustainable case against the entity on the face of the pleading, subject to later identification of the individuals involved. And it's also worth pointing out, my lords, in connection with SIB's reliance on SOFA, that in this case, there had already been, by the time SIB pleaded its case in the particulars of claim, pre-action disclosure and the provision to the liquidators of witness statements from the 6 individuals directly involved in managing SIB's accounts, whom SIB had named in Section 263 proceedings. All of that, my lords, is set out in Mr. Flack's evidence. On the back of that information, SIB pleaded a factual narrative about SIB's relationship with HSBC that your lordships will see runs to 36 pages of its pleading before one even gets to the particulars of negligence. Since the hearing before Mr. Justice Nugee, SIB has had disclosure. 7,900 documents were disclosed in tranches between the 30th of October 2020 and the 18th of December 2020. A further 483 documents were disclosed in mid-January. Since then, there have been a few odds and sods added to the disclosure, such as depositions of expert witnesses in the US proceedings. That's the proceedings brought by investors against HSBC and other banks in the US arising out of these same facts. So SIB has had the bulk of the disclosure for a matter of months, not weeks, and one would expect analysis to be well advanced by now. We say we are now well into the realms of McCorberism, with the idea that the smoking gun which has so far eluded SIB is about to emerge. By striking out the claim, rather than giving summary judgment, the judge left the door open just a chink if some radically different case on dishonesty did emerge on disclosure, subject always to whether SIB could bring itself within the boundaries of Section 32 of the Limitation Act. But Mr. Fenwick's determination to create a new theory of corporate recklessness speaks for itself. SIB doesn't expect any such new case to emerge. My lords, we say this is not an area of developing law where a view could not be safely taken ahead of trial. The relevant law is settled. There's no coherent basis for the suggestion this is such a novel case that the existing law can't new approach is needed. This is therefore, we say, an exercise in applying some very well-established legal principles to SIB's pleading. And I'll start with the legal principles to set the framework for our analysis of the pleading, and then move on to the pleadings, which I can take relatively shortly since Mr. Fenwick has already taken your lordships to them. My lords, it's beyond argument that the essential ingredient in dishonest assistance is dishonesty, and SIB accepts that. SIB also accepts that on the law as it stands, the court cannot rely on aggregating a series of honest minds to produce a dishonest mind. And yet SIB is also suggesting that the law can and should develop in a way that would accommodate its pleading. Our position is simple, that the cases are settled to the effect that dishonesty is an essential element in the cause of action, and that the first stage in the test for dishonesty is subjective and involves establishing what the person said to have acted dishonestly actually knew or suspected. Only once you've done that can you move to the second objective stage. And in the case of a corporation, that means the subjective minds of individuals whose dishonesty is attributable to the corporation. You can't add together innocent minds to get a dishonest corporate mind. So in a corporate context, we say the effect of that, the fundamentals in terms of what the test is for dishonesty, have the consequence that when you're alleging dishonesty against a corporate body, at least one individual has to be found who's dishonest and whose dishonesty can be attributed. You apply the objective stage of the test to the subjective mind of that individual. And that is how, my lords, dishonest assistance claims have been advanced in other cases, including, at first instance, in Singularis and Dewa. And let me just note, my lords, that Dewa is one of the largest securities and capital groups in Japan, according to their website, which Ms. Hutton has just Googled, and I think it's also clear from the report in Singularis. They are a major bank, or rather broking company. So Singularis and Dewa at first instance, also, my lords, Bilter and NatWest at first instance, which was before Mr. Justice Nugee, and I can come to what we said in our skeleton about that case. And then at the level of the Court of Appeal, my lords, in Group 7 and Nazir, which, as I'll come to, raised questions of attribution to corporate entities. My lords, what you can't do is synthesize a dishonest corporate mind for the purposes of that first subjective stage, and on that basis declare the entity to be objectively dishonest. Now, as I'll show when I come to the detail of the pleaded case, aggregation is both expressly one plank among SIB's alternative formulations, and also, we say, creeps in by the back door in its supposedly aggregation-free alternative case. And, my lord, that was very evident in the way that Mr. Fenwick developed his submissions this morning, because he kept referring to the overall knowledge of HSBC as though that was something he was entitled to synthesize. His case fundamentally depends on that notion of aggregation. We can pick up pretty much everything we need from Group 7 and Nazir. Your lordships have that at tab 33 of the authorities bundle, and I know you've already been taken to it. But can we actually start with paragraph 4? I'll find it myself. Paragraph 4, which is page 1175 in the PDF. Sorry, my lord, I'm just checking my marking here. Yes. If your lordships look down that paragraph, you'll see that the starting point is the brazen fraud. Fraud was followed by an attempt to launder the proceeds using the client account of a London firm of solicitors, Notable Services LLP. Notable was a multidisciplinary partnership whose members included Mr. Martin Landman, an accountant, and then 2 other individuals who were solicitors. The present proceedings concern attempts to recover the unreturned balance from Notable and others, including from a bank employee, Mr. Luangeli, who was alleged to have dishonestly provided information to Notable, and from the bank that employed him. So, my lord, in Group 7, all of those, and the LLP and the bank were also defendants along with the guilty individuals. Your lordships have seen the legal test for dishonesty referred to at page 1183. And Mr. Fenwick took you through the ensuing discussion. But the important point there is all of this is being debated in a case where it is not only the dishonest individuals who are before the court, but also the relevant corporate bodies or legal personalities. Your Lordships will have seen from the passage cited from Lord Nichols at 1184 the emphasis there on the subjective element. That is inescapable here. And at 1185, my lords, paragraph 37, concept of reckless disregard of another's rights. My lord, reckless disregard can be a telltale sign. Yes, of course, but recklessness is not of itself to be equated with dishonesty. It may be evidence pointing to the conclusion that the ingredients of dishonesty are in fact there to be uncovered. But in this context too, as is very clear from the passages you've been taken to in Group 7, you have to take into account the circumstances subjectively known to the individual who is behaving recklessly. So, for example, and we'll come to an example of this later in Greenwich, if an individual is actually aware of a risk that a particular transaction is fraudulent and participates with reckless disregard for the rights of others affected by that fraud, that might be evidence of dishonesty. But whether it is actually dishonest will depend on the same two-stage test. You don't escape the need to identify a subjective mind with the relevant state of mind, namely knowledge of the risk and reckless disregard for the risk. And of course, we emphasise paragraph 38, where negligence is dismissed as a sufficient basis for dishonest assistance. We say the effect of the submission that Mr. Fenwick urges upon your lordships would effectively render corporations liable in circumstances where the particulars relied upon amount to no more than negligence and would give rise to nothing more than liability in negligence in the case of an individual. My lords, at 1192 paragraph 57, again, in relation to blind eye knowledge cannot include what a person ought to have known but carelessly did not know, or suspicions a reasonable person would have formed but which they did not in fact form. All of that is out of bounds. And again, if you were to allow what was not known but should have been known to enter into the first stage, the first subjective stage of the dishonesty test, just because in a given case the defendant's a corporation, you would drive a coach and horses through the whole test and the key distinction between honesty and dishonesty that has been approved up to the level of the Supreme Court. And, my lord, one has at paragraph 58 the reference to the fact that it must now be treated as settled law that the touchstone is indeed dishonesty.
I mean, just to be clear, Ms. Robertson, this case is not sitting on the docket in Westminster, is it?
Sorry, my lord, I didn't understand.
This case is not being appealed to the Supreme Court.
This case, no.
No, not this case. The case we're looking at, Group 7.
I'm not aware. Let me just check whether Miss Hutton knows anything about it. We're not aware of there being any appeal pending in Group 7, my
Well,
lord.
you can just check. Your
Yeah, we can check.
On the Supreme Court website, it just saved me a job.
Absolutely, we will do that, my lord. Now, 1193 in the PDF, one goes on to the subject of blind eye knowledge, and manifest shipping is referred to for the notion of the targeted suspicion and conscious decision not to inquire. My lords, let's not overlook the fact that in manifest shipping, the defendant was a corporation. So in manifest shipping, that test was formulated in the context of a corporation. And the court proceeded by identifying a subjective guilty mind and proceeding by way of attribution. In fact, no such guilty mind being found, but nevertheless, that was the approach that needed to be taken to the problem. One has confirmation at the top of that page 1194, my lords, that the principle stated in manifest shipping applies with equal force to the law of accessory liability, because of course it came up in the context of privity in relation to insurance.
I mean, presumably you place some reliance on Lord Scott at paragraph 116, saying that blind eye knowledge, the suspicion has to be firmly grounded and targeted on specific facts.
Absolutely, absolutely, my lord, and that can only happen if we're talking about a human mind who has that thought process.
And to allow it to be constituted by a decision not to inquire into an untargeted or speculative suspicion would be to allow negligence, albeit gross, to be the basis of a finding of privity.
Yes.
Yeah. So
absolutely.
you say that's what Mr. Fenwick is trying to do.
Yeah. We do say that, my lord. So he's trying to transform a Quinscare case, what you should have suspected, into a dishonest assistance case. What you did in fact suspect is the necessary component in the latter. My lords, Mr. Fenwick also took your lordships to paragraph 61 and the notion that suspicions that actually fall short of blind eye knowledge might come into the equation in the overall state of mind. This again is all about the fact the only way you can get to dishonesty is analysing the content as a matter of fact of that human mind. So we say all of that, which has been deployed over and again in cases which do involve the question of the liability of a corporate body, is wholly inconsistent with aggregating innocent minds. It requires you to be able to assert that there are individuals, even if you can't yet identify them, whose conduct, beliefs and knowledge meet that test for blind eye knowledge, and then attribute that. Now I'll come later to the suggestion that's now made that one can somehow spell out of the pleadings such an allegation against the higher-ups, if we can put it in those terms, at HSBC. My lords, what we say is, even if, as happened in SOFA, you're not yet able to identify the individuals, you at least need to allege against the corporate body, as an entity, the requisite form of blind eye knowledge that ticks all the boxes one sees identified in manifest shipping. You must at least be able to allege that the entity held a suspicion which was firmly grounded, targeted on specific facts, and deliberately refrained from confirming the existence of the facts it suspected, not out of negligence, even gross negligence, but crucially, because it would rather not know. So in manifest shipping, the claimants failed on the evidence to show that the master of a ship had blind eye knowledge of its lack of seaworthiness, such that the assured, a corporate body, was privy. And no one suggested that the requisite knowledge could have been synthesized out of components known to an array of different people, or things that weren't known but should have been known, just because the assured was a corporate body. Mr. Fenwick also took your lordships to the passage in Egypt, Africa and Jackson, which both sides have cited. It's at paragraph 15 of our dishonesty skeleton and in the authorities tab 8, page 142. We don't need to turn it up again, but the true distinction emphasised there between honesty and dishonesty, that distinction is just as critical when the defendant is a corporation. It is not a matter of indifference to a corporation to be accused of dishonesty. And since it is that must depend on the dishonest state of mind of individuals, those individuals are entitled to know that that is what they are accused of. And I've already said why SOFA is not a parallel for this, and I'll come back later in more detail to the pleadings in SOFA. But the fact of the matter is, one has to be able, come trial, to identify who those individuals are. And in this case, SIB's expressly pleaded case, it is not making that allegation against anyone. So on that basis, the existing pleading is flawed and unsustainable. SIB would need to make the argument, if it were able to do so by way of amendment, that that amendment should be permitted, bringing itself within Section 32 and addressing the impact on a trial which is now only some 7 months away. But that is a wholly hypothetical scenario as matters stand. So, my lords, what we derive from that settled body of case law is that in the context of a corporation, just as in the context of an individual, it is not enough to say that an array of individuals, however foolishly, failed to form any suspicion, as opposed to forming one and then deliberately ignoring it in order not to have the suspicion confirmed. And your lordships would make a nonsense of the critical distinction emphasised in Agip if one could aggregate the minds of those foolish individuals to arrive at a dishonest supermind on the basis of the notional turning of a corporate blind eye. And we say that in fact that is what Mr. Fenwick is seeking to do. Now, as specifically to the word recklessness, my Lord Mr. Justice Arnold rightly questioned in what sense that word was being used by Mr. Fenwick. As Lord Justice Miller said in Armitage and Nurse, and your lordships have this at tab 13, page 225, between C and D, simply sprinkling that word through a pleading can still leave in doubt whether the words are being used in a technical sense or merely to give colour by way of pejorative emphasis. And to illustrate that distinction, being reckless in the sense of not caring one way or another about the truth of a statement you present as true is dishonest. Saying that someone's failure to put 2 and 2 together and come up with 4 is reckless is just a pejorative epithet, unless what you mean is that there was deliberate obtuseness on their part because they suspected but didn't want to be confronted with the fact that the right answer is 4. Now, if that's what you mean, that's what you must plead in terms, and there must be someone with that state of mind, whether or not you can yet identify them by name. My lords, could we move to Clydesdale and Workman at tab 26? As one sees, my lords, at paragraph 1 of that report, that case related to whether 2 solicitors were guilty of dishonest assistance in relation to a mortgage fraud. And the court considered whether it was sufficient to prove that the defendants had been reckless as to the existence of the bank's equitable rights. If we could go on to paragraph 48, sorry, let me just find the page number. It's on 875 in the PDF. that brings me to the third way in which Mr. Stewart put the case. He said it was sufficient to prove that Mr. Murphy and Mr. Denslow had been reckless as to the existence of the bank's equitable rights. It was reckless to have allowed the entirety of the sale proceeds to be paid to Mr. Hayward without making further inquiry about the extent of the monies secured by the Hayward charge. I'm not convinced that recklessness is equivalent to dishonesty in this area of the law, although it's undoubtedly evidence of dishonesty. Lord Nichols made this point in Tan, and then the citation which your lordships have already seen, and indeed the citation from Lord Nichols in the next paragraph, telltale sign. Picking it up again at 50, again, Lord Nichols is not saying that recklessness is dishonesty. It is, or rather can be, a sign of dishonesty. If the judge had found that Mr. Murphy and Mr. Denslow did not care whether or not the Hayward charge secured more than the proceeds of sale, that would perhaps have been reckless and a sign of dishonesty. But he did not make that finding. They both said that after discussion they concluded the Hayward charge trumped the bank's charge. And then at 51, what in my judgment is missing from the judge's analysis is any consideration of why Messrs. Murphy and Denslow acted as they did. It's true that the judge found they followed the instructions given to them by their client, but that, in my judgment, is to stop the inquiry too soon. Why did they take the view they had to follow their client's instructions? If they'd simply decided they had to follow their client's instructions willy-nilly, that might be sufficient to found a conclusion they were reckless. But their evidence was not that their client's instructions trumped the bank's charge. It was that the Hayward charge trumped the bank's charge. And then at 52, the judge ought to have confronted that defence head-on, unless he was able to conclude he did not believe it, which he did not say. I do not consider he was entitled to find they were guilty of dishonesty. Now, my lords, that's a case against individuals, but it demonstrates what the internal components of recklessness have to be before you can be saying that you are alleging that as a form of dishonesty. The word recklessness is, as it were, an empty vessel. It's just a label by itself, and it may mean, it's equivocal as to what it means. It may mean gross negligence. It may mean dishonesty. You need to make your case clear in that respect, and you can only bring it home as dishonesty against individuals and also as against a corporation, we say, if what you're saying is, as was here, that you had recognised a risk and simply not cared about the impact on the party affected if that risk eventuated. Now that depends necessarily, therefore, on a subjective state of mind, recognising the risk, the relevant risk on our facts being the risk that SIB was being run fraudulently as a fraudulent business. Someone would need to have recognised that risk and decided that they didn't care. And that, my lords, is not alleged, as we will come to. The criticism of the individuals who are hands-on responsible for managing SIB's account is not that they didn't care, but that no one put two and two together and realised that there might even be an issue as to whether SIB was being run fraudulently. In respect of the word recklessness, Mr. Fenwick also referred, my lords, to the passage in Quince Care where Mr. Justice Steyn referred to a banker who recklessly fails to make inquiries. And I won't ask your lordships to turn it back up. What I say about that is that Mr. Justice Steyn in Quince Care was not concerned in that case to define dishonesty, and it's understandable he resorted to a form of judicial shorthand. Where a bank fails to make inquiry, the question will always be the question that was asked in Clydesdale Bank and the question that Mr. Justice Nugee asked. Why? Unless you allege that it is because the bank suspected and didn't want the suspicion that suspicion confirmed, or that the bank recognised a risk of fraud but just didn't care, recklessness is just a label for gross negligence. I'll have more to say about recklessness when we come to the pleadings, my lord, but moving on to aggregation, SIB's case in its grounds of appeal and its skeleton is that there's something novel about its case that takes it out of the norm, such that a special rule of attribution needs to be formulated. Now, my lords, it's as well to look at what the norm is that has generated the principle. Before Mr. Justice Nugee, there were some 10 authorities showing the courts rejecting aggregation as a means of arriving at a guilty corporate mind in a variety of different legal contexts, civil and criminal. We need only look at 2 cases in the bundles, and in fact perhaps one of them we can take very quickly, because Mr. Fenwick has already taken your lordships to the principle in Armstrong and Strain. What I want to show your lordships is how that principle was applied in the judgment of Lord Denning in Z and AZ. If your lordships would go to the supplemental bundle of authorities and the 3rd tab in that bundle, page 84 in the PDF.
Right, I'm not sure I've got a supplemental bundle of authorities. Do you mean the one you produced today?
No, my lords. Your lordships should have had a supplemental bundle containing 3 authorities: Liggett, Reclead and Trust, which I referred to yesterday for the point about benefit in the context of restitution, and Z, Limited and A. So if that hasn't reached your lordships, we'll need to rectify that now.
Hasn't reached me, I'm afraid. I did get, let me just check, I thought I had Liggett.
I have the supplemental bundle.
I'm grateful, my lord.
No, I'm afraid I don't, but you carry on and I'll...
We'll make sure it's sent through again just now. Miss Hutton can attend to that. My lords, if I could, meantime, simply read it out for your lordships. This was a case of contempt of court, and Lord Denning turns at C to the question of how knowledge may be established when it's sought to attach. Pardon, my lord, it's on page 84 of the PDF at C. I now turn to the question as to how knowledge may be established when it's sought to attach a corporation for contempt, where a servant acting in the course of his employment knowingly assists in the breach of the terms of the injunction, the employer corporation will be responsible on grounds of vicarious liability. And then further down, what is the position, however, when a bank clerk who has no notice of the terms of the injunction pays out on a cheque after notice of an injunction freezing the account has been given to another person employed by the company? The position could be said to depend upon the status of the person receiving the notice and the relationship between him and the person making the payment. In my opinion, however, in all cases, it should be necessary to show that the person to whom notice was given authorised the payment, or knowing that the payment was likely to be made under a general authority derived from him, deliberately refrained from taking any steps to prevent it. I do not think it should be possible to add together the innocent state of mind of 2 or more servants of the corporation in order to produce guilty knowledge, and then referred to Armstrong and Strain, saying it was applicable to a case of contempt of court in assisting in a breach of injunction. And there's there a reference to the fact that mens rea calls for the application of principle. Now, obviously, I accept we don't use the term mens rea as such when we talk about dishonest assistance, but we are talking about a subjective state of mind based upon knowledge. And from that perspective, there is no distinction to be drawn. It goes on to refer to Armstrong and Strain and the passages from that your lordships have already been referred to. And then, my lords, at sorry, there's a particular passage I was going to refer your lordships to, but I've lost it here. Ah, sorry, yes, I'm in the wrong place in my notes. I think that's all that we need from that, the point being that that was as against a corporate body applying Armstrong and Strain in relation to the question of whether the corporate body could be taken to have the requisite knowledge. And it's in fact Greenridge that I intended to go to for the passage I was thinking of. If we could go to tab 27 in the main bundle of authorities, we say that Armstrong and Strain is a principle deeply embedded in our law, and one sees an example of it applied here, where one has Mr. Justice Nugee applying the principle in the context of a claim against the vendor of a property to rescind the contract for fraudulent misrepresentation, where the vendor was a corporate body. Now, I accept, of course, it's a misrepresentation case, but the important part is that the analysis doesn't differ because of the fact that the defendant is a corporation. So we could pick it up at paragraph 77, page 903. At paragraph 77, the law does not recognise any conception of composite fraud, then referring to Armstrong and Strain. And also it's convenient to pick up here the passage one sees cited from Armstrong and Strain at paragraph 79, because we haven't actually seen that yet. Difficulties may arise in a claim against a company which can only speak or act through its agents or officers. But if an officer of a company writes and represents that which is untrue, when many other officers of the company know the true facts, it may well be found he made the representation without belief in its truth, or he made it recklessly, carelessly, whether it was true or false. That must depend on the evidence. Now, my lord, that's important because it shows that the lordships in Armstrong and Strain, although dealing with a case involving agent and principal, did not overlook the question of corporations and how the principle would apply in that context. And as regard the scenario that is posited there, yes, where one person in a company writes what others know to be untrue, it will be a matter of evidence whether you can prove that the writer was dishonest in writing what they did. The conclusion may be that they knew what others knew or deliberately didn't find out. But obviously, if that was your case, you'd need to plead it in those terms. You would plead that the individual who made the statement was dishonest on that basis. It would not be a case based on aggregation. My lords, we've not burdened your lordships with the decision of Mr. Justice Snowden in Bilter and NatWest, which was before Mr. Justice Nugee, because, of course, we're enjoined not to multiply authorities that are simply examples of undisputed principle. But, my lords, perhaps I could take your lordships to what we said about that in our skeleton below, which will be in the supplemental bundle, tab 5, page 160. Sorry, I think, yes, it is. It's the foot of page 160 in the bundle. In Bilter and, sorry, I've called it RBS. It's variously referred to as NatWest or RBS because, of course, it's the same entity. Snowden J considered and rejected the possibility of aggregation in the context of liability for dishonest assistance. So this is specifically dishonest assistance against a big corporation. I do not, of course, suggest that the separate states of knowledge of the traders can be combined in any way for this purpose. It's necessary to investigate the individual states of mind of the two traders separately. So the way in which Mr. Justice Snowden arrived at his conclusion was this, that the knowledge of the senior trader could be attributed to RBS for the purpose of assessing whether RBS was dishonest, because he had allowed a subordinate trader to continue with the requisite knowledge as the line manager with responsibility for that trading, and he did nothing to stop his subordinate, the subordinate not having the requisite guilty knowledge. So, perfectly large corporation here, and no suggestion whatsoever that one could properly approach it by reference to aggregation, still the classical manner of doing so, by reference to the dishonesty of a given individual. it shows that our case is far from novel in raising the question as to whether and how a corporate body can be found liable specifically in dishonest assistance. And nor, we say, my lords, is uniqueness to be found in the fact that SIB's alleging against HSBC failures in respect of the application of its policies to SIB. In Singularis and Daiwa, my lords, the claims advanced at first instance in the alternative were for breach of the Queen's Care duty or for dishonest assistance. I don't think we need to turn it up, but it's in your lordship's bundle at tab 28. We address it in our skeleton at paragraph 54, and the reference for that is tab 5, page 65. I can just summarise and give your lordships the relevant references. At paragraph 204, at first instance, that's page 968, Mrs. Justice Rose agreed with the claimant's submission that Daiwa had a dysfunctional structure leading to a sequence of events where everyone assumes that someone else is dealing with investigating the disputed payments, but no one troubles to check whether that's right or not. What went wrong was that no one seems to have considered it his job to make the inquiries that Mr. Wright said should have been made, or to ensure that the right people were tasked with dealing with payment requests. Now, all of that formed part of her reasoning in finding a breach of the Queen's Care duty, but counsel for Singularis, Robert Miles QC, conceded that Singularis had to show that a particular person within Daiwa was dishonest. That's paragraph 147, page 954. The claim in dishonest assistance failed because no individual had behaved dishonestly. We say the concession in Daiwa, again a case against a large corporation, was rightly made, and there was correctly no suggestion from Mrs. Justice Rose that Daiwa's dysfunctional structure, which resulted in a failure to carry out the relevant inquiries or carry out the relevant checks, was at all relevant to the dishonest assistance claim. A meltdown, and even a spectacular meltdown, as in Daiwa, in systems and processes that are supposed to ensure that knowledge is collected and passed on within a corporate body, is not a unique circumstance calling for Armstrong and Strain to be abandoned as a principle and some new and novel basis for attributing dishonesty to a company to be found. My lords, as to the legal principles relating to what's an adequate pleading of dishonesty, we summarise those at paragraph 12 of our skeleton, tab 5 in the core bundle, my lords, and it's at page 52, I think. So I've just typed the wrong page. So none of this, my lords, is controversial, but it's as well to remind ourselves of it. Fraud or dishonesty must be specifically alleged and sufficiently particularised, and will not be sufficiently particularised if the facts alleged are consistent with innocence. And we say the underlying particulars relied upon are indeed consistent with innocence. By innocence, of course, one does include negligence, innocence as distinct from dishonesty. Dishonesty can be inferred from primary facts, provided those primary facts themselves pleaded. There must be some fact which tilts the balance and justifies an inference of dishonesty, and this fact must be pleaded. And then thirdly, the claimant doesn't have to plead primary facts which are only consistent with dishonesty. The correct test is whether or not, on the basis of the primary facts pleaded, an inference of dishonesty is more likely than one of innocence or negligence. I'll come to SOFA when we've looked at the pleadings, as it's better dealt with in a manner which is specific rather than abstract. But if we could go now to the statements of case, which we can take quickly because Mr. Fenwick, I'm elevating Mr. Fenwick. Mr. Fenwick has already taken your lordship lordships to them. Just by way of reference, my lords, we do summarise the relevant sections of the pleading at paragraphs 19 to 34 of our skeleton argument. The reference is core tab 5, pages 53 to 58. And then we go on to make our submissions on how the legal principles apply at 35 onward. Now, what I was proposing to do was to work through our submissions about what's defective about the pleading whilst going through the pleading itself. So starting with the particulars of claim, your lordships have already seen that this is expressly put forward, and this was paragraph 613, which Mr. Fenwick took you to, on the basis not that any one individual had the requisite knowledge, but on this theory of corporate recklessness. Your lordships will have seen the lengthy factual narrative about SIB's relationship with HSBC. If we could just jump forward to page 233 and paragraph 172, I should just pause there and say, we do not accept, in fact, that an individual who had all the knowledge on which SIB relies would have formed the suspicion that SIB's business was fraudulent, but I do accept that that's a debate for another day, that's a debate for trial. What matters for our purposes in this application is that SIB's complaint against HSBC is that no one person did have that knowledge. And what one sees cross-referred to at paragraph 175 are the paragraphs at 157 to 163 above and 168 above, all of which constitute SIB's pleading of the Quince Care breach of duty claim. And your lordships were taken swiftly through that by Mr. Fenwick. Pattern of activity on SIB's accounts with HSBC, where the complaint, to summarise, is that until the 1st of August 2008, money accumulated in the accounts rather than most of it being sent out to be invested, as SIB had said at the outset to expect. And SIB, for the most part, didn't insist on getting interest. As from the 1st of August 2008, what's said to be suspicious is the volume of withdrawals and the fact that holders are being paid out of cash deposits containing money that came in from other CD holders. Now, of course, my lords, there's nothing wrong with that if SIB had been solvent. These weren't trust funds. It's a creditor-debtor relationship. Come trial, there will be a debate as to whether it's realistic to expect HSBC excuse me, to monitor a correspondent bank's activity against that bank's own predictions rather than applying automated monitoring relative to past activity and peers. But in principle, that allegation is put as one of negligence and one in circumstances where the activity on the accounts, of course, would have been equally apparent to SIB itself. It cannot be said in those circumstances that an inference against HSBC of dishonesty is more likely than an inference of negligence. Paragraph 160, your lordships were taken to for SIB's annual report for 2007, a copy of which we accept HSBC was given. And what's being said is if one had got one's pocket calculator out to work the various percentages in a forensic analysis of the figures, because let's be clear, the figures, the percentages that Mr. Fenwick refers to are not stated on the face of the report, one would then have figured out that SIB's business was too good to be true and the audited financial statements were not to be believed. And again, of course, those statements were, of course, known to SIB itself. How can it be said that the failure to get out the pocket calculator raises an inference more likely of dishonesty than of negligence? And then one gets on to paragraph 161, the general concerns relating to SIB, where we get a mixed bag of points relating to money laundering risks in Antigua, Mr. Stanford's political connections and influence in Antigua, the fact that on SIB's board there's Sir Courtney Blackman, who'd retired from the position of ambassador to the US some 10 years before, and who, I emphasise, SIB does not accuse of any involvement in the fraud. So a bunch of points best described as odds and sods, drawn from the public domain. So the argument there is that HSBC, not that HSBC knew them, I think, bar perhaps one subparagraph, but that HSBC ought to have gone out, trawled around, and found that information. So same point, how can one say that those facts raise an inference more likely than not of dishonesty? One then goes on to SIB's critique at paragraphs 162 to 163 of HSBC's compliance with its own policies and processes, and it said there are manifest deficiencies in KYC. It wasn't renewed when it should have been. Now, the thrust of that is that HSBC had failed to collect and record adequate KYC information about SIB. But KYC, at risk of stating the obvious, just means know your customer. SIB itself, knowing all it did about its own business, didn't know or suspect that it was a Ponzi scheme. So how is it being said that these allegations of negligence in relation to KYC give rise to an inference of dishonesty in that respect? My lords, one has at paragraph 164 as the culmination of the Quinscare case, what it's alleged that the reasonable banker armed with this knowledge would have thought. If your lordships look, and this is at page 224 of the first subparagraph there, the reasonable banker, aware of all the facts and matters that SIB relies upon, would have been concerned that HSBC's failure to follow its own procedures meant that it had no basis to conclude that there was no cause for suspicion. And then later on, one does have the allegation that there were clear signs of a Ponzi scheme. It's an allegation that puts Quinscare on its head, Quinscare articulating the point that the starting point is trust in business relationships. So that's the unpromising substructure on which Mr. Fenwick then seeks to erect a superstructure of dishonest assistance in paragraphs 172 and following, which I was about to come to, but my lord, perhaps I should come to those after the short adjournment.
Yes, I take it we're in good time.
I believe we are, my lord, yes.
Very good. We'll resume at 2 o'clock then. Thank you very much.
Thank you.